Hey guys, welcome to my legal classes. This is Ganesh Pujari, and in the series of administrative law, I am going to start 3 video series on administrative discretion. In the first video, we are going to understand administrative discretion, the meaning, the purpose or why do we need administrative discretion and the different types of administrative discretion. In the second video, that is one important aspect, that judicial control over administrative discretion with lot of case laws we are going to discuss. And in the last video, I am going to discuss two important doctrines, that is doctrine of proportionality and doctrine of legitimate control. With that brief introduction, let me get into the meaning of administrative discretion. Before even getting into the meaning of administrative discretion, let us try understand the word meaning of discretion. In a simple way, it can be defined as the freedom to decide what should be done in a particular situation. You must have watched or observed while watching the TV programs, they will mention that parental guidance is required for children below so and so age. What is that? That is the discretion for the parent to decide whether to show such contents, like it may be having crime or horror or porn content. In that situation, parents have to decide whether to show such programs to their children or not. That is the parental discretion. That way you can understand the term meaning of discretion. Now, Justice Coke has beautifully defined the term discretion, and along with that, he also gave a kind of guidance that how should be discretion utilized. He says discretion is science or understanding to discern between falsity and truth, between right and wrong, between shadows and substances, between equity and colorable glasses and pretenses, and not to do according to their will and private affections. So, how should be discretion used? It should be used for truth, it should be used for right, it should be used for equity, all those stuff, but should not be used for particular person's will or private affections. That is how Justice Coke defines and give guidances. Smith says administrative discretion is a power to make a choice between alternative course of action. Whenever there is option between administrative authority, he has a power to choose between those alternatives, which is called as administrative discretion as per Smith. Freud says administrative discretion means the determination reached upon the basis of consideration not entirely susceptible, subject to or proof of disproof. Now he is giving the other context, whereas Davis says administrative discretion is a power which gives a public authority a free hand to make choice among possible courses of action or inaction. He says it is a free hand to make choices between the possible courses of action and inaction, whereas Marcos says administrative discretion means a statutory power. Davis says it is a free hand, whereas Marcos says it is a statutory power confirmed on a public authority to make choice or to available alternatives on considerations which are not possible to be declared beforehand. So that means law or rules cannot control everything beforehand. Sometimes there will be situations where the authority has to make decision on the spot itself. In such case, it will have certain discretions which is given by or conferred by the law, which is administrative discretion as per Marcos. I hope this is sufficient content as far as meaning is concerned. With that, let's move on. The next question is, why do we need administrative discretion? There are 5 important reasons I have brought in this particular slide, and the first one being the state was earlier police state where security and protection of people was given a lot of importance, whereas now it has converted to welfare state with the concept of laissez-faire. That means happiness of all people, which is the new thinking of all the citizens. So with that, lot of discretion is also required for the administrative authorities. So the administration discretion has developed. Secondly, complexity and varying nature of problems, which makes difficult for law to define everything. So there is requirement of discretion to be used by all the administrative authorities. So we have this concept. Thirdly, new problems will bring new scenario, and we don't have experience on those particular new scenarios. For that, we need to give authority to the administrative authority to take their own discretions or use their own discretions to complete that particular case. So we have got administrative discretion. Fourth one, difficult to foresee everything that is happening in the society, because society is changing every day. and you cannot have law for every single aspect. What is there today may not be there tomorrow, or what is not there today may not come tomorrow, or what is right today may be wrong tomorrow, or what is wrong today may be right tomorrow. So in these scenarios, the administrative authority needs to use their discretion as per the changing requirement of the society. For that, we need the discretions of the administrative authority. Last one, changes circumstances from case to case basis. There will be decisions to be taken based on a different locality, different situation, different persons. The administrative authority have to make the decision. For that, we need administrative discretion. Now, if they ask you to critically examine this particular aspect, you can bring the definition from Lord Acton, who says every power tends to corrupt and absolute power tends to corrupt absolutely. So the discretion to be given or not to be given can be discussed with this particular definition. With that, I am moving to types of administrative discretions. The last aspect that we are discussing in this particular video is types of administrative discretion, and this is a very simple slide where I am discussing subjective and objective types of administrative discretion. Now, what is subjective? If a decision is made on the thinking of a particular administrative authority, that means he uses his mind based on his thinking way. In that case, it is subjective, whereas objective is on happening or not happening as per a statute. And if on happening or not happening something, if he is getting additional authority to make a decision, that is his discretion as per objective discretions. Now, subjective discretion can be easily said as when the authority is empowered to set his own limits to determine the criteria for a decision. Like, for example, if the statute is using the term if he thinks fit, or if in his opinion, or if it is his deemed opinion, all those circumstances are example for subjective discretion. Whereas in objective discretion, for example, in Companies Act, there is a mention that authority can appoint inspection if there is a fraud operation. That means if fraud happens, then he has the discretion to appoint inspection. So that is objective discretion. This is all about the subjective and objective types of discretions. Now the last question is whether an administrative authority can make decision on his whims and fancies. Now for the answer, you need to wait for my next video, which is on judicial control over administrative discretion. Thank you so much for watching me. Please subscribe my channel. Please like, share and comment my videos. All the very best for your exams, and thanks again.